Preponderance of evidence is one type of evidentiary standard, meaning there are more. And when it comes to evidence, there are standards. Preponderance of evidence is one type of evidentiary standard used in a burden of proof analysis. This is self-explanatory. Whoever has the burden to prove a claim. Under the preponderance standard, the burden of proof is met when the party with the burden convinces the fact finder, which is the acting judge, that there is a greater than 50% chance that the claim is true. This is the burden of proof in civil trial. A fact finder is also known as trier of fact. A fact finder is an impartial person, aka the acting judge, or examiner designated to appraise the fact underlying a particular matter of the case, aka juries. We're going to give you an example. When it comes to jury trial, it's the jury. When it comes to bench trial, it's the acting judge. Preponderance of evidence. What is the functional aspect of what this greater than 50% chance that the claim is true? What does it mean? When most people bring a claim, whether they're claiming something to the Attorney General or they're bringing something into a court case, either as a plaintiff or a defendant, there's a consistent pattern where people narrate an incident and consider that narration of incident evidence. There's a difference between evidence and to narrate something. Most people merely narrate the events and bring no evidence. The preponderance of evidence is to show what you're narrating. The narration is the 50% of what's going on, because that in and of itself, if unrebutted or if there's no opposition, becomes fact. This is the misconception about people that says an unrebutted affidavit remains a fact. But there are many loopholes within the rules of civil procedure and affirmative defense, aka parliamentary procedures, aka ancient laws, that everybody intrinsically know how to do, but yet when it comes to things of this nature, we all ignore. The narration itself is 50% even if you put it in the form of an affidavit, but there are many presumptions that's put in the form of affirmative defense, whereby that affidavit does not become the law, especially if you're a defendant, or even if you're a plaintiff, because you have the burden of proof beyond reasonable doubt, meaning your words is not enough, even if you put it in the form of an affidavit, because there are many other loopholes where they're going to come in and start talking trash. Part of it is the 19 type of objections which we went over in the past. If you don't know those, it will probably be beneficial to be savvy to how those work. So your narration being 50% of the facts, the other 50% is the preponderance of evidence that makes it 100. If you say something happened and you actually don't have the evidence itself that it occurred, whatever it is that you're saying is not there to be seen, observed by the trier of fact or the fact finder, then your affidavit does not become the law, because that affidavit must be supported by preponderance of evidence, one way or another. If you're saying that someone maliciously prosecuted you, what is the evidence of that? The evidence of that is the case being dismissed regarding the supposition that they brought against you in the first instance. Whatever crime they say you committed, if it was dismissed and then you're coming back and now suing them, that dismissal of that thing that they claim against you is the evidence of the malicious prosecution. Bring in the transcript, bring in the previous court order that says that it's been dismissed. You're saying that they had no probable cause. What is the preponderance of evidence of them having no probable cause? You can put all that narration, you can narrate that on a piece of paper that they have no probable cause. But what is the preponderance of evidence of that? The law itself, regarding the requirement of what probable cause mean. But if you do not know what probable cause mean, how would you be able to claim on an affidavit that they had none? Your narration is the 50% of it, even if it's in the form of an affidavit. The preponderance of evidence is the other 50% that balances the whole equation and make your claim whole in order to state a claim upon which relief can be granted. Besides that, there are two more things that a lot of people miss. There are elements and tests. If the claim that you're bringing does not qualify for the elements of the rights that you're claiming and does not pass the test that's associated with that right that you're claiming, because two people can claim the same right, but the circumstance that gave rise to the claim of those rights might be different. Hence, a qualifying factor is the test that exists. Those elements and the tests also account for the 50% that serves as preponderance of evidence. So to remove the presumption that a lot of people have been accepting that an unrebutted affidavit remains as law, that is true. But where there's a requirement of preponderance of evidence, which 9 out of 10 times there will be, that affidavit alone does not stand as law. And on top of that, there's many loopholes as to how that affidavit and the liability it's creating can be abated. Whatever it is you're narrating in your affidavit is wholly insufficient against someone who knows what they're doing. The lawyers and attorney that the majority of the people are going against know these loopholes and know these foundational principles. The question is, do you? Take care. Best of luck.